Come back. Be seated, please.
All right, our next case this morning is a civil case, GEOGHEGAN. I think I've already messed it up.
GEOGHEGAN, isn't it?
GEOGHEGAN?
GEOGHEGAN.
Versus GEOGHEGAN. And Mr. Walsh, I understand that you have filed an appearance.
Correct, Your Honor. Your Honor, I would like to 15 minutes of my opening argument, reserving 5 for rebuttal, if I may, please.
The clock counts down from 20, so
Yes, sir.
when it shows 5, that means you've got
sir.
5 left.
Yes, sir.
All right, so you may.
My name is Michael R. Walsh. I'm from Orlando, Florida. I'm appearing here as co-counsel for the appellant today. I was not counsel in the lower court, nor did I brief the case. It was briefed by Pamela Huddleston. Now, we are appealing from an amended final judgment of dissolution of marriage, which was entered on May the 11th of last year. This is a long-term marriage, a 31-year marriage.
Hey, I know you didn't write the briefs, but so I
Yes,
want
sir.
you to kind of help me with it
Yes,
a
sir.
little bit, if you would. It was a little hard to follow. The income figure that the judge used for the husband, former husband, was like $250-something thousand. He got it off a W-2.
$259,000, which included the bonus and the base salary
Right.
for 2006, although he had just received a pay raise. I don't know that that was included.
All right. Now, as I understand it, he did not put back into that the deferred comp contribution,
That is correct, sir.
which the W-2 was net of that, right?
That's correct, sir. There were
And he
two.
didn't put back the money that goes into the medical reimbursement plan.
No, sir. There was the evidence at the court trial level showed that there was $13,000 in pre-tax contributions to the 401k, $4,800 to an SERP, a supplemental employee retirement plan, which were not counted. In addition to that, the stock options had been regularly exercised, and those were not in any way imputed, nor were any income imputed from the performance sharing.
I wanted to ask you about that. Now, did he exercise any in the year that the W-2 for the 250-something represented?
Let me be specific. From 1995 on through the trial, in the 10-year period before that, stock options were regularly issued. And he exercised them each and every year. The evidence at the trial level showed up to the year 2000, there were $220,000 of stock options exercised. The year of the trial, the year that it was the filing, was 2004. There was another 100,000. So in that period of time, there was 300,000. There were 600,000 of exercisable shares at that time, which indicated that over the period of time from 1995 to 2004, or 9 years, there were $900,000 worth of stock options, or approximately almost $100,000 a year, which was not imputed as income.
But when he exercises those, the income is the difference between the option price and the market.
That's correct.
When you say 600,000, you're talking about the gross.
I'm talking about the gross. That's correct. The 900,000 being measured.
But in the tax year that the judge used to determine his income, did that represent any income from the exercise of stock options?
It exercised, the court factored in what he had done during the pendency of the case, which was $100,000.
Okay.
What he had done, he had taken and cashed it in, and then he had paid off a home equity loan, and then had taken the money back. It was very difficult to find out the financial managerations going through, because he had planned this divorce for a period of 2 years. And she was completely clueless.
In the $259,000 figure, which
Yes, sir.
included the exercise of some options, is that correct?
That was not included in the options. That was bonus and base salary.
Okay, so the 259 does not include the exercise of any options.
No, sir. Nor does it factor in the contributions that were made to the 401k, nor the SERP, nor another $5,000 that were made to a medical savings plan.
Now, with respect to the options that were vested prior to the dissolution, the judge went through and established a formula. Are you okay with that formula?
No,
or
we're
is
not
your
okay.
focus?
No, we're not. We're not
Okay,
okay.
so
with the formula.
you're unhappy with the formula that he used for the ones that were vested prior to the dissolution, as well as his failure to include any income from those looking forward.
That's correct.
Okay.
And I'll be happy to tell you why.
Well, why don't you tell me this? Tell me if you were writing on a clean slate. To me, the more difficult question is, how do you value, if at all, if we should value at all? What is your best argument on why we should value stock options that might or might not be granted in future years? And if so, how do we value them?
I will be more than happy to answer that question for you. The Jensen case is from the First District Court of Appeals, and the facts in this case are almost identical with the Jensen facts. We have in this situation stock options that were granted and issued. We have a 2003 plan from the employer that says if an employee dies or becomes disabled, those vest. In addition to that, we have a capital control and a capital structure differential that says if the company changes hands, that they vest. Now, the Jensen case and the Perry case says the key is this: is there any actual non-marital effort involved after the final judgment as to these? We've got the foundation theory, and they came in during the marriage. And we submit to you that even if Mr. GEOGHEGAN did not work one single day after the final judgment for matters outside of his control, these stock options would vest. They would vest. Now, dealing with the second, we're talking about the performance sharing. They're a little bit different. They are on a cliff vesting, which is similar to the Florida retirement plan. They vest 1/36 each month, but they are not at all exercisable until the third year. And those pro rata vest upon death, disability, or again a change in control. So there is no circumstance one day after the final judgment for matters not within his control that he would not have these vested. Now, this is to be contrasted with the authority relied upon by the trial court, which was the Rutberg case out of the 2nd District. Now, the Rutberg case out of the 2nd District, the man signed a signing bonus. And each and every document that went before the trial court talked of the future. It talked about wanting to keep this employee in the future. It was not like this case, which are commendable, which rewards one with the rendition of the stock options and their issuance of the stock options because of past efforts. This case is like Jensen. These are for past efforts. They're not for any future efforts. Now,
well, but my question, I
Yes,
think,
sir.
with respect to looking forward is it your contention that, for example, if 5 years from now, assuming he's still employed and alive and just, not
sir.
disabled, if he gets some options 5 years from now, is it your contention that the value of those options should be included in his income for alimony purposes?
there is a component there, yes, sir. Yes, sir, there is a component.
And what is the marital component looking forward versus those that accrued during the marriage or prior to the dissolution?
Well, I believe that at the time of the final judgment, there's a number of factors that play in here. I believe at the time of the final judgment, if the court were just to take this isolated instance, Mr. GEOGHEGAN testified, Judge Orfinger, that he used the stock bonuses from 2000 on to pay family expenses. And he used the $100,000 he received the year of filing to pay family expenses. That's $300,000. Even if you took those over 10 years, that would be $30,000 that could be imputable. But by the same token, if you take the totality of the circumstances that we have in the Fitzgerald case that we cited to you, you have to add back the 401k, you have to add back the medical savings plan, you have to add back the SERCP. So we're much more,
Mr. Walsh, I think
we're much more than the 259, and the alimony would be set on that.
Can I interrupt you for a minute, please?
There would be a component in there.
I think you're missing the point. What we're trying to get at is, if you're sitting as the trial judge and you know that Mr. Gagan has historically gotten a series of stock options over the year.
Yes, sir.
How do you value that for income purposes?
All right.
Okay, in the future.
That option was presented to the trial judge. There was an expert witness available. Mrs. Gagan had psychiatric problems. She had health problems. She wasn't able, to aid her lawyer. She offered an expert witness by the name of Dale Russell, who would testify for her and on her behalf, and he would take the values as established from the evidence and would bring to the court's attention proposed areas of equitable distribution which would bring out a yield of income, which would answer Judge Orfinger's question, because then you would have a true sense of what income is to set the alimony. What the court did in this case by neglecting to do that is the court set the alimony before the equitable distribution and did that after the fact. And that's the entire problem that we have. Furthermore, Mr. Gagan...
Was the expert rejected by the court?
Yes, sir, he was rejected. The court said that the court believed that if the court were to listen to this evidence, it would be usurping the court's authority to set equitable distribution, and this would be something that the court had to decide itself. Now, we submit to you...
The problem that I'm having in understanding the argument is that equitable distribution relates to the division of marital assets. What I'm struggling with is not the equitable distribution. I mean, I agree with you that we've got maybe some issues that we've got to look about. Maybe did the judge leave out the 401k or the SERP? Maybe we've got to look at those. It seems to me that the issue that I'm struggling with is the idea that historically Mr. Gagan has gotten a sum of money every year in stock options, which he can't exercise by and large for a while. There could come a time, depending on how things work, that some of the options might be underwater.
That's correct.
Historically, that hasn't happened, I guess, most of the time.
That's correct. But
we all recognize it could happen in a given year or years. My concern is, what I perceive your argument is, that because he has regularly gotten the options and used the value of the options as he's able to cash them out to contribute to the family expenses, in other words, enabling them to live at a higher level than they might otherwise live on their base salary. Is it your contention that for purposes of evaluating his income available to pay alimony, that we should include the value of options that may or may not be granted in the future, that may or may not be underwater in the future? And if so, how do we tell the trial judge to value them? I get the impression that the answer is yes, we should include them.
No, not necessarily. That was the fallback argument. I believe what the trial court should have done in this case, Judge Orfinger, is this. I believe in this particular case the court should have looked at the vested and unvested stock options that had existed at the time of that trial and made a determination that these were marital assets subject to equitable distribution. With that, you wouldn't reach the imputation argument.
Okay, so your argument then, just let me see if I can reduce it. Your contention is that any options that existed that were actually on the books as of the date of the separation or the dissolution, I don't remember which one the judge used, that were either vested or not vested, should
vested but issued, yes, sir.
Right. Should be considered as marital assets for equitable distribution.
Absolutely.
And you're not worried then about if 8 years from now he gets some stock options that we haven't even thought about yet. You're not worried about that?
No.
Okay.
That would bring us in, I would not make that argument to you today. That brings us into the ACRA decision. That brings us into modification of alimony. It brings us into all kind of other ramifications.
So your idea is that 7 or 8 years from now, if he gets a bigger stock option grant and his income goes up substantially, or likewise if it goes way down and he wants to seek a modification, either party could seek a modification based on change of circumstance.
That's true if the stock options had been equitably distributed at the time of the trial. That is my argument.
Well, but my question relates to options that don't even exist now.
That would be something off in the future. What I'm saying to you...
So you're not worried about those options?
That would be a modification question.
Okay.
I think my time is up right now.
Thank you, sir.
Good morning. My name is May Ann Downs. I'm from Orlando and representing the former husband, Mr. GEOGHEGAN, in this action. There is a certain confusion, I think, that comes from this record as a result of the fact that there are numerous components to the former husband's income. He has a base pay at the time of the hearing found by the judge based on substantial competent evidence of $178,000. I beg to differ with the former wife's characterization of the income in this action because at Record 677, the amended final judgment, the trial court found that his income for purposes of the action at the time of the trial, the final hearing, was $259,000, not the $178 base salary, quote, inclusive of base salary, bonuses, stock options, performance shares, and existing restricted shares. Now, the confusion
Did that include his 401k, his pre-tax optional, deductions, his medical reimbursement plan, and that
the judge, I think there is a gap in this record potentially about whether that $13,000 and $4,800 was included. But what the judge did was take the base salary, take the testimony about the various options and performance-based and company performance-based components, and whether that $13,000 plus $4,800, I don't know. I'm sorry?
Use W-2?
Use the W-2 based on the prior year. You'll recall, I think from the record, the former wife wanted to use the 2004 W-2, but that was when he liquidated $100,000 and distributed, the court required actually distribution of $150,000 to the parties as part of the temporary order.
Let me ask you this in the abstract.
Yes, sir.
It would be inappropriate for the judge to not include the $13,000 and change in an income determination, right?
Judge, I think that income, if the trial court said, I'm going to exclude as a matter of law all the retirement income, yes, sir, I think that would be error. But, Judge, the reason I don't think that matters in this record is fourfold. Number one, the income was determined listening to all the evidence about the various component parts to this man's income. The only sure thing he had is $178 if he doesn't lose his job. Number two, remember that the benchmark in this record that the trial court struggled with and we submit an admirable job is the lack of proof, the almost complete lack of proof by the former wife about what her need was. She submitted into evidence a financial affidavit that included temporary support payments to her as an expense.
Aren't we confusing two different issues? When you talk about the lack of evidence as to what her needs were, that goes to the setting of the amount of alimony. Yes. I think what Judge Torpey's question was directed at was for purposes of equitable distribution and for determining what his base income is. should the 401k plan, should the pre-tax medical plan, and any other pre-tax benefit plans that he might have available to him be put into those, because those aren't going to show up on his W-2?
You're right, Judge. Neither of those components will show up on the W-2. And the $13,000 and the $4,800, again, if the trial judge said, I'm going to exclude these,
Wait a minute,
but
what
what
is
he did is come up with an entire
$13,4,800?
I'm sorry, Judge?
What is $13,4,800?
$13,000 was the amount contributed during that year that they used the W-2 as a benchmark to the 401k, and I believe $4,800, I think it's an even amount, was the amount that was contributed to the medical savings
Medical
plan.
savings.
$4,800, I believe, to the medical savings plan. So
I mean,
those are the
those
two
arguably
numbers.
have two different components. In the year of the
Yes, sir.
dissolution, they may be subject to equitable distribution, and looking forward, they may be a component of income.
Yes, sir, they do. They do. But here's the problem with this trial court order. The trial court was given no information about need, and I realize your point about that being the alimony, and so he went with the best that he could, blending the evidence in the record and relying primarily on the former husband's financial affidavit and his testimony, because the wife said she was unable to handle that. She wasn't good with books and records. She wasn't good with financial records. So that's the alimony part of it. On the equitable distribution, recall, of course, that she actually got a greater share of equitable distribution. So from our way of thinking, Judge Orfinger, the question is, has the former wife demonstrated error to you? And the amount of income we submit, the determination of the amount of income, is a factual matter to be decided below, and if there is competent evidence to support it, then the question becomes, has she shown you such a clear discretion based on the evidence that was submitted at trial? Because with all due respect to the former wife, you don't get to come over to Daytona and say, well, we'd like another shot. We have another equitable distribution scheme and another alimony scheme we'd like you to consider. The court heard this over a period of 3 days, listened to motions for rehearing, and issued an amended judgment. Back to the stock options and the cliff options and the performance-based awards, I wanted to go back to a question the panel had. There was a reference throughout, or repeated references throughout the brief, and also heard here today. Those are all lumped together as if they're somehow always had occurred and always had been distributed. Stock options had been distributed, but of course stock options are only, can be liquidated and turned into income if if the corporation's value of the stock price goes up. But the cliff options and the performance-based component was not regular. In fact, the performance-based component in the 5 years prior to trial, 2 times the company had met it, but modestly. 3 times the company had not. So when you lump it all in together as a stock option and you say each and every year he got a stock option and each and every year he spent hundreds of thousands of dollars, it sounds like there's a whole lot of money left on the table. And in fact, the former wife complained throughout the proceedings that the husband had dissipated assets, but after testimony at trial, the wife's counsel actually herself said, now I understand it. So there's a suggestion that there's all this money floating about that the trial court failed to deal with, failed to distribute. We submit the equitable distribution went in her favor on unequal distribution. The trial court found income greater than the base salary, and that's a factual issue, and there's substantial competent evidence to support it. And in addition, although the former wife will tell you of all sorts of ways they wish it had happened, the question is that an abuse of discretion? And I'd also like to address briefly some things that appear also in the brief and also you heard this morning, and that's a reference to psychiatric problems. This is a woman who had 2 accidents and had an ACL knee repair, and at the time of the proceeding, in other words, when the parties separated, she was seeking counseling. But at no time was there any evidence in the record to suggest any disability or inability to proceed with trial or inability to present evidence such that she should get another shot at it. The question, and also on the issue back, Judge Orfinger, to your question, as this court well knows, Whether and under what circumstances a distribution is made is heavily influenced by a finding below, a determination the trial court's able to make based on substantial competent evidence about how much of these awards are based on future income and how much are reward for past. The evidence in the record was virtually undisputed about that. And I say virtually because while there was an expert who did give some testimony, he had no knowledge of that particular company, was not a member of management, hadn't interviewed any management, hadn't reviewed materials except one brief description of the way the stock options work. So, three components then of the stock option awards. One is the trial court understood the distinction between the three kinds of performance-based criteria. Number two, the court found they were for future services, not deferred compensation. Number three, the court provided a constructive trust analysis on the marital part of those options, as the Jensen case, and I believe the Perry case as well, suggests is the appropriate way to deal with the complex question I think, Judge Orthinger, that your question at least alluded to. And so what we're left with is, has this party, this appellant, come to you and said, there's no evidence to support 259. The overwhelming evidence supports less. The base pay was 178. The court blended it together, 54-paragraph final judgment, amended after an initial one of, I think, 49 paragraphs. And although people who don't do as well at trial as they'd like, including my client who didn't get what he wanted, would often like to come and tell you another way to do it, the question is, the proof was put to the trial court. Trial court has a right to make the determination of income, the determination of assets, and there is no demonstration of error on the part of this court. As to the $13,000 and the $4,800, my question to this court would be on the hypothetical notion of reversal, which part of the 259 do you tell the trial judge to redo? The trial judge took a lot of arguments and questions about income. He blended them together, heard the testimony, came up with a number, and they can't tell you that it's not supported by evidence in this record. And we respectfully suggest that's the test. If it's supported by evidence, then we suggest that you should affirm. Thank you, ma'am.
Very briefly, the evidence before the trial court showing the 259 came from the W-2, it came from the bonus, and it came from the salary. I want to point out that it excluded some $23,000 of other pre-tax contributions. The medical plan, the 401k.
Where in the record is that? Counselor?
Pardon me?
Where in the record is that?
That is in the record in the husband's testimony when he testified that every year, Judge, he saved 10% of his base salary, 10% of his base salary. $13,000 went into the 401k, and the balance of the level over that, $4,800 went into the SERP. Now, as to the stock options, very briefly, I think this is the problem. If the court were to consider the areas of equitable distribution and to take the record evidence that is before it and allowed Mr. Dale Russell to testify as to the yields that would come from the available, and we say admitted, marital assets before the court, then the court would have been in a more intelligent position, a more determined position to set the alimony. For example, the husband testified that the $220,000 of stock options from 2000 to 2004 had been exercised to pay family debt. The other $100,000 that he received in that time, which is $320,000, if you were to take that over even a 10-year period, that would add another $30,000. You could impute it for the alimony purposes, but not beyond that if you didn't want to distribute it as an asset. By doing what he did, he gave the husband, who did not carry his burden of proof as to show this was a non-marital asset, the unvested stock options, but he also had before him income which was in excess of $300,000 a year, and allowed her only 20% or $60,000 as a lifestyle need, which he did not find, and only 16% of the net income. So the problem confounded itself. It just created the problem when he did not allow the testimony of Mrs. Gagan's witness, and there was very good cause to show that. The trial court in the final judgment found that this woman was not even capable of supervising repairs on the home, and they had to have a third person supervise the repairs because she was unable to do it. She couldn't even help her own lawyer in filling out her financial affidavit. Now, another thing that's very important in light of the Bacon case, which is cited in your brief and other cases, is it was a rush to judgment for rehabilitative alimony with a 57-year-old woman. And immediate employment and immediate income being imputed to her when she hadn't worked for 22 years. Not only that, there was a tack-on of COBRA insurance, which would only be good for 3 years, and she'd be 60 years of age when that would run out and would have no health insurance. Now, the last point I want to make to you, and the fundamental thing here, is she was denied attorney's fees and costs. Clearly, there is a disparity in income. Clearly, there's a disparity in assets. She has nothing left under the final judgment except for retirement plans, 401k and her SERP, which she has to pay a penalty or tax to get into. And she would strip herself of the money that she needs to live in her old age and whatever money she gets for the house. So on a combination and using the Gentili case, looking at the totality of the awards and circumstances, I submit to you under the strongest possible terms that this final judgment should be reversed in its entirety, except as to the dissolution of marriage, and remanded for another hearing. Thank you.
Thank you, counsel. Thank you both. Well-argued case.